In this video, we're going to talk about the limits on agency power. To prevent agencies from having too much power, there are limits that are placed on them by all of the branches of government and the public. Let's start with statutory control. This is Congress. Congress's enabling legislation of an agency can set the limitations, especially on their powers, such as having a formal hearing versus an informal hearing. So Congress can actually outline those limits. We also have the Administrative Procedure Act, which imposes controls and basic fairness rules when agents use its power. We also know that Congress has the power to abolish an agency as well. So that could be looked at as a way of controlling the agency. The executive branch, or political control, while the president influences the executive agencies, as we already discussed, Congress also controls the money and the funding. An agency that maybe angers Congress can be defunded or budget cuts, and as I said just a moment ago, even abolish it. Also, Congress has approval over any presidential nominees to those heads of agencies and the independent agents, the agencies that we talked about. Prior to the approval, Congress will make all sorts of inquiries of the individuals, like their intentions. What are their intentions in running the agency? So all of that plays a role in controlling the agency power. And of course, judicial review. Any individual corporation who believes they're harmed by an agency's rule, investigation, or adjudication may have that action reviewed in a court of law. I've kind of touched on this a little bit already in the previous videos, but the key here is the party must have suffered a direct harm. Somebody can't go to court and say, you know what, I don't like that agency decision. I don't think it's fair. I don't think it's right. Unless that party was harmed in a direct way, you can't just show up to court to challenge the rule. Some examples I've given of cases. Some other ones, Pearson versus Shala. That was a significant case that dealt with the authority of the Food and Drug Administration, or the FDA, to regulate the marketing and labeling claims made by dietary supplement manufacturers. The case itself looked at the First Amendment rights of manufacturers, their ability to make claims about their products versus protecting consumers from the product. The lawsuit was brought by Pearson and Shaw. These folks were the promoters and authors of dietary supplements. They challenged certain FDA regulations that restricted their ability to make certain health claims about the supplementary products. Pearson and Shaw argued that the regulations violated their right of First Amendment free speech. So the crux of the case revolved around the Dietary Supplement Health and Education Act of 1994, which was established to regulate dietary supplements. It was all the new craze, right, to take supplements. So the FDA had issued regulations regarding those supplements and the restrictions that were placed on people making health claims as a result of taking the dietary supplements. And the Federal Appeals Court that heard it analyzed whether or not the FDA's regulations infringed on First Amendment rights. And the court said, while we recognize commercial speech, that's what advertising and promoting is, commercial speech that includes marketing and labeling claims that are made by manufacturers, it is recognized as being protected. However, there is some level of protection for our consumers and the ability for the government to regulate any speech that might make false or misleading claims. So in its ruling, the court upheld or supported FDA's authority to regulate health claims made by dietary supplement manufacturers. The court determined that the regulations were reasonable. They were related to a government's interest in preventing deceptive and misleading claims. The court also noted that the regulations did not prevent manufacturers from making legitimate claims about their products. Rather, they aimed to ensure that claims were substantiated and not misleading. So that's one example. Another one that I found that was interesting, there's tons of them, This case went all the way to the Supreme Court, the one I'm going to tell you about now. It's Federal Communications Commission versus Fox TV. The case addressed an issue of indecency in broadcast television and examined the FCC's regulations and enforcement of its indecency policy. The case itself stemmed from several incidences which occurred on live TV on award shows. I think Billboard Music Awards, maybe the Golden Globe Awards. So what happened was for Cher, the singer, performer, actress, entertainer Cher, she said, people have been telling me I'm on my way out every year, so I just say fuck them. That's what she said on the Billboard Music Awards on a ceremony. That occurred, and then a year later on the same program, Billboard Music Awards, Nicole Richie asked have you ever tried to get cow shit out of a Parada purse? It's not so fucking simple. Those were said on live TV. The U.S. law under the FCC, the Federal Communications Commission, the U.S. law bans the broadcast of any obscene, indecent, or profane language. So the FCC regulates the broadcast industry. They had issued some guidelines indicating that the utterance of an isolated vulgarity was acceptable so long it was not repeated at length. After Nicole Richie explained the difficulties of cleaning her purse, the FCC declared a more stringent indecency policy. The stricter standard made a single fleeting expletive punishable if the word was deemed patently offensive, quote unquote. That was a term in the law, patently offensive. But the FCC did not give a clear definition of what that term is, and it enforced the new rule quite unevenly after it was passed. For example, it allowed bad language during news interviews and films, but condemned the same words in other sort of contexts. When the FCC found that Fox had violated the agency standards by broadcasting Cher Nicole Richie's 3 words, Fox argued that the new policy was too vague and arbitrary. So went to court, went all the way up to the Supreme Court. The issue the Supreme Court looked at was whether the FCC's indecency policy was vague and arbitrary. The court said yes, it was. The FCC failed to give broadcasters fair notice of what kind of conduct could be punished, and it did not apply the rules equally to everyone. The court reasoned that the FCC has the right to set and change its policies. However, laws must provide a person of ordinary intelligence with reasonable notice of what behavior is prohibited. So how could Fox have known that the fleeting, F word on live TV was going to be forbidden when at other times it wasn't? It was allowed. So clear rules need to be established and set forth. Another limit on agencies' power actually is kind of indirect. Public scrutiny. That seems to keep agencies in line. One of the most important laws that were passed by Congress, and each individual state has their own version as well, is the Freedom of Information Act. In New York, we call it Freedom of Information Law, or FOIL. You might hear that term, FOIL request. That's what they're referring to. The Freedom of Information Act allows anyone access to information that either a federal, state, or local agency has or are using. The idea behind this is transparency. So anyone can make a Freedom of Information request. There are some guidelines. It must be in writing. It has to be furnished to the agency that actually has the information, where this information is sought. It's a very easy process to make a request. Nowadays, you can just do it online. You can go to the agency's website and, proceed to enter your request. The ease of getting information, however, is not quite as the same as making the request. An agency has 20 days to acknowledge receipt of the request and whether it will comply or deny the request. Sometimes they ask for more information, or can you be more specific if it's a broad request. There are a number of exceptions to the rule of furnishing requested information. A couple of the more prominent ones: national security, invasion of an individual's privacy, the information is part of an ongoing investigation, and there's several other ones. If a request is denied, there is an appeal process. within the steps that have to be taken within the agency to where you requested the information. Large news outlet, the New York Times, uses FOIL all the time. They're constantly bringing agencies to court over the failure to comply with a valid Freedom of Information request. I remember New York is very liberal in the Freedom of Information Act. We've actually, we legislators have passed laws that allow for individuals and entities seeking information to collect attorney's fees if they actually have to fight to get that information. So if somebody makes a reasonable request, it's within the bounds of the law, the information is there, but for some reason the agency isn't turning it over, and an individual has to pay to go to court with an attorney to get that information, courts can require that agency to pay that person's attorney's fees. That happened fairly recently with the Buffalo Bills, the new stadium, and a news outlet requested information from the governor's office asking, how much is this going to cost? It basically wanted a breakdown of the costs involved, and they didn't turn it over and wasn't turning it over, and the case was brought to a court, and right before the court appearance, the state agency turned over the documents as they were required to do, and when they got to court, the agency argued, well, we turned over the documents, Judge, this point is moot now, and the court said, no, it's not moot, you should have turned it over before this case got to court, I'm issuing attorney's fees. So anyhow, there are some punishments if agencies are not turning over documents as required, but it also, freedom of information, also this idea of the level of compliance is dependent upon which administration is at the helm. Just going back a couple decades, George Bush after 9/11 tightened up the laws on freedom of information, not allowing so much transparency. The Obama administration made it a little bit more lax. The Trump administration tightened it again it became very stringent to the point where there were federal agencies that removed the online request for information, made it a little tougher to get information. The Biden administration loosened that up. As I said, the laws in New York are a little bit more liberal for freedom of information requests. That might not be the same in other states in this country. So nonetheless, informational control and the public could be an area that keeps agencies' powers at bay. So this concludes the discussion on administrative law.